Legal disclaimer. Bespoke Group investment advisory services are offered only through Bespoke Advisory, an SEC-registered investment advisor. Everything we share here is just for information and education. It's not investment, legal, or tax advice. Bespoke does not offer or solicit investment services to the general public. And as always, investing comes with risk, including the possible loss of principal. In today's episode, we have 45 minutes. And I have a long agenda for us. So I see us as being able to kind of tease out several topics. And then for our listeners, there is on the episode page of our website, there is a box where you can submit questions or comments on areas that you want to hear more about or have us elaborate on. So I want to set up today's conversation with just about Bitcoin and other crypto assets that are on the agenda right now for estate planning attorneys. And it's on the agenda because clients already own it and it's sitting outside of existing structures. Regulated custody now exists, and Bitcoin and other crypto assets require the same level of structuring and rigor as other assets. And so today we're really talking to the established estate planning attorney who is listening to this conversation, because they're at a transition point. There is an opportunity, right, for them to evolve their work and be a part of the future. And it does require, I think, getting out of the comfort zone and, moving forward with the next generation. But I think what's very exciting is that I'm speaking to the estate planning attorney, all of your knowledge is relevant, and it's relevant for these assets. And there are two pieces that I see, that we see, that are really kind of the connective tissue to activate all of that knowledge, which is qualified custody and communicating with these new client types. So that's the connective tissue. You don't have to say no anymore. You can stay in the driver's seat, build your practice, and engage beyond the previous generation.
I think we can stop right there.
Yeah,
I mean,
covered it all.
That's pretty much it. You mentioned that Bitcoin and other digital assets not only require the same type of planning. The cool thing is they also benefit from the same type of planning that other assets benefit from. What we've seen is, we've been in this Bitcoin space increasingly since 2017 when we started working with clients in this space. And even since then, at that point, Bitcoin had just hit its all-time high, just under $20,000. And it was a crazy new asset back then, but for a family and for a handful of people, it was a tremendous amount of wealth in dollar-denominated terms. Fast forward to 2026, and I mean, as of recording time, Bitcoin's around $75,000 per token. So it's gone 3x and some change since 2017. All of the same planning strategies are on the table that every estate planner knows about. Revocable trusts for long-term continuity and probate avoidance, and then every dynasty trust, grat, slat, slant, non-grantor trusts and jurisdictions that permit them. Everything is on the table for these digital assets. And there's a tremendous amount of wealth held by people in the United States who have Bitcoin and Ether and other digital assets. And these people need your help. They need your help, and they are a tremendous opportunity because this wealth is maturing very rapidly.
Yeah, that's great stuff. And Claire, I want to circle back to something that you mentioned a couple times in your intro, which is the concept of custody. Because while Matt's exactly right, you can use existing planning structures to incorporate new technologies and new assets into the fold. But from my seat, custody and knowledge about how things move from point A to point B is just of paramount importance, because people I find the biggest struggle for them is they don't know how to house these assets. They don't really understand what it means to own Bitcoin versus owning a share of stock, let's say, where you have a transfer agent. Something happens, you call up the transfer agent. Yeah, there's hoops to jump through, but there's a delineated process as to how to get those assets moved from one person into an estate or to an heir or what have you. When it comes to digital assets, it's a much murkier road. We know what those steps are, but your average person does not. And what you see in a lot of instances is people, they have a lot of Bitcoin or Solana or Ethereum or whatever it may be in their portfolio. Something happens to them and nobody has any idea how to get it out of their wallet or their Coinbase account or wherever it is. And as of now, it's estimated, I believe, that approximately 3.5 to 4 million total Bitcoin have just been lost. People own them and they're gone due to lost seed phrases or lost wallets or whatever it may be. So it's really incumbent upon us and you, the viewer and listener, to understand that that's part of the process now. You have to know, almost like a scavenger hunt, you have to leave the breadcrumbs for somebody to be able to find those things. If you are a person who does self-custody, it's really important to leave that roadmap so people know how to find those assets. Otherwise, you're just leaving wealth behind.
Yeah, let me. So, Claire, I think this is a good opportunity for us to explain why why this is why it is so important and why it is challenging. The Bitcoin has been analogized to digital gold. Ether, Solana, different types of digital assets, they all have very similar qualities. They're fundamentally different in economic ways, but from a ownership perspective, they're all pretty much the same. And where it comes down to is these are bearer assets, just like gold is a bearer asset. There's no title to a physical piece of gold. There's no title to a bag of precious jewels. There's no title to a bag of coins or to a bag of cash. The thing is value in its own right. And to my mind, it's not even worth exploring whether these things are valuable. The market has spoken. These are valuable. So if you're listening and you've been cynical and avoiding Bitcoin and the broader crypto asset space, you've already lost that argument because the market, to the tune of $2.5 trillion, the market believes that there's value here. And because these are bearer assets, planning for Bitcoin, planning for crypto assets is very much like planning for physical gold or planning for another asset that has inherent value in itself, but no custodial title to it. As Kyle was talking about, if you've got equity, your equities are usually at some type of transfer agent, especially if it's a publicly traded company. You've got Tesla shares, you've got Apple shares, you've got Microsoft shares, you've got whatever it is. Those are sitting in some account somewhere. You can transfer ownership of those underlying shares simply by transferring ownership of the account in which those assets are held. So you got a Schwab account, you simply title that to the Kyle Lawrence Irrevocable Family Dynasty Trust, or whatever you want to call it. Now, if you have a bearer asset, you have physical gold. Let's assume that you have direct custody of your gold. It's not sitting at a gold broker. It's sitting in a vault that you own and control. How are you going to get that gold into a dynasty trust? Well, first of all, you're going to design the dynasty trust, and you're going to appoint a trustee who has sophistication in dealing with gold. You're then going to have that trustee inform the drafting attorney what kind of special language we need to have in here, since we're going to be heavily weighted toward gold. Do we need to waive the prudent investor standard? Do we need to modify the prudent investor rule? Do we need to tailor the investment policy statement within the trust instrument so that the trustee can hold perhaps a disproportionately concentrated position in gold, for example? Okay, that's great. Now you've done that work. Does the trust hold the gold at this point? No. You've got a trust that's ready to hold the gold, but you haven't done anything to transfer the gold from your unilateral vault at your home to some vault controlled by the trustee. So the trustee has to open a vault, they have to establish a vault, to which the trustee and only the trustee has the combination to the vault. Then you, the one who is creating this trust, the settlor, you have to physically relocate your gold from the vault to which you have the combination to the vault where the trustee has the combination. You cannot simply move your vault from your house to the trustee's office and you keep the combination. The trustee has to be able to control the gold in the vault. So we have to allow the trustee to establish custody of the gold in this case, and the trustee alone has to have the combination to the lock. This is the metaphor for Bitcoin and for other crypto assets. If I'm going to put $5 million, $10 million, $100 million into irrevocable trust frameworks, I have to have the trust instrument carefully drafted in a way that accommodates the idiosyncrasies of holding an unusual asset like Bitcoin. And I, the settlor of the trust, have to then physically, I suppose, transfer my Bitcoin from a vault that I have the private key, read combination, to that vault, and then transfer that Bitcoin to the trustee's vault that the trustee controls. I cannot continue to control the combination to my vault. I have to give that away to a vault that I do not have the combination or private key to. So that's the TLDR on how to do this.
I want to shift away from custody for a moment and talk about your respective clients, generally speaking, because it's very common to group all of cryptocurrency together as one piece. So I'm pulling the thread here on planning for Solana, planning for Ethereum, planning for Bitcoin. Yes, you said this, the solution, they can be treated as, this type of asset. There is kind of a similar nature then we move into title held. Okay, fine. However, these cryptocurrency is different than Bitcoin, is different than, they're not all, it's not a blanket statement. And I want to take this as an opportunity to, I was going to put it lightly, but how about I just say to just shatter the idea that cryptocurrency and Bitcoin is only young white dudes. I mean, yes, that's part of the community. Kyle, I know, I remember when we were at dinner, you were talking about, your work has been involved in, NFTs, for example, you were Moish. And then Matt, I know your work is when I think of the work around Bitcoin, I'm thinking of very serious women who are using their Bitcoin for philanthropy. So those are two very different, right? That's a lot more interesting than just Bitcoin's young white dudes and young white, Bitcoin bros. So can I hear a little bit more about your respective kind of client types?
Sure. It's a great, interestingly that you asked that question a week before Bitcoin 2026, which is a fair amount of, younger white dudes, but it does take all kinds. The conference has grown and it is certainly more of I would say it's an evolving, diverse group of people who are interested in it, as with most things, because a couple of years ago, Bitcoin and other digital assets were still very niche. So really people who are just more familiar with financial products would be more likely to be interested in it just by the nature of what they do. And finance bros or whatever you want to call it, it's just predominantly that. But that has evolved in recent years. And as you have a greater adoption and more accessibility to these products, you just see the people who are holding it is naturally diverse, as it should be. I mean, the whole ethos of Bitcoin is removing the power from the banks and giving it to the people. You control your own assets, not the banks. So that's it's just an interesting observation. But the conference is next week, and I'll take pictures to prove it. But to circle back, my clientele really runs the gamut. I have high net worth individuals who, either got lucky with certain investments or got into Bitcoin when it was, a couple dollars, and they lucked out and held on to it, didn't sell it at $3,000 or whatever it was. We have a lot of other people who are not necessarily ultra high net worth. They're just everyday blue collar folks who are looking for another way to expand their portfolio. Maybe they've been burned by the stock market, or they don't fully understand it, or they've run into problems with transfer agents, as Matt was talking about, whatever it may be. So this is another way for them to just expand their financial growth. We also have a lot of companies who set up digital asset treasuries on their balance sheets. They have a lot of excess cash. It's just kind of sitting there, not really doing anything. The interest rate you get from the bank is pennies on the dollar. So what do you do with that cash? Let's put it to work. Let's invest in Bitcoin. Let's invest in Ethereum, or whatever asset it may be. So it's really a wide swath of people that we as a law firm have under our tent. High net worth individuals, average everyday folks, companies. And then there's also on the tech side, people who are trying to develop the infrastructure around which these assets will grow. We hear a lot of talk about institutional adoption and upgrading payment rails and payment systems in this country. Well, the folks doing the work who are building those guardrails and are building the mechanisms by which Bitcoin or another form of cryptocurrency moves from point A to point B, that's who we are working with on a day-to-day basis. And it's really exciting, even though it's a bear market. Bear markets are good because it weeds out the riffraff, and the people who are still involved and are still doing this every day are folks like you guys who do a great job at educating the public, and other people who are really serious and see that, this is a new frontier. We're heading west, as the bankless guys say, and it's great stuff, and we're all here for it.
Yeah,
Bankless guys and gals.
that's right.
Well, the bankless, the podcast specifically, that's their tagline.
Oh, right, totally.
Yeah, the something Kyle hit on is worth zeroing in on a little bit more. At this point, we're up to this point, I suppose, most of the people who have made wealth with Bitcoin and the broader digital asset space, I would say, are on the tip of the spear of innovation. They are computer scientists, they're cryptographers, they're privacy maximalists, and they, as Kyle mentioned, they acquired Bitcoin early, or they acquired Solana early, or Ethereum early, and they believe in the decentralized power of compute in the case of Solana and Ethereum, or the disintermediated transfer of value in the case of Bitcoin and other digital assets. And a lot of the clients that we see aren't necessarily those who were at the tip of the spear of innovation. Some of them certainly were. Some of them were married to people who were at the tip of the spear of innovation. And those people either divorced or died. One of the first clients I took on back in 2018 was the mom of a young man who was, I can't remember what chain it was, but he was maybe Optimum or something like that. It was part of the early framework on which Polymarket is now built. He was one of the core engineers. And at the time when he died in 2018, 2019, his stake was about $10 million. He had no family, he had no children, he had no wife, but he had a mom. And that mom inherited $10 million worth of this digital asset. And she reached out to us to help her try to navigate, what do I do with this? How do I do this? Some of the clients that we have are clients who, one is a woman who inherited it when her husband, who was at the tip of the spear of innovation, died. He had been an early Silicon Valley entrepreneur, very successful, made a fortune in Silicon Valley, discovered Bitcoin in 2011, 2012, and picked up a few thousand tokens because, what the heck. And then by the time he died, those few thousand tokens was worth a couple $100 million. She didn't even know it was there. But in going through the documents of this gentleman's estate, she discovered this trove of Bitcoin that needed structuring and planning. Another client who is still probably our largest Bitcoiner to date, her ex-husband was at the tip of the spear of innovation, and he had mortgaged the house back in 2011 to buy Bitcoin. And if one mortgages the house without telling your spouse, you can probably figure out which way the marriage is going. It did go that way. And when they divorced, she ended up with a massive amount of Bitcoin. And then other clients were just early, probably more libertarian-minded, privacy-focused, sound monetary policy advocates who were university students, just pursuing a degree. They were pursuing a doctorate degree, but come 2010, 2011, they hear about this thing called Bitcoin. They plug in a laptop and start mining because you can, and mined several thousand Bitcoins. Meanwhile, while they were pursuing their graduate degrees, they held on to it, and their graduate studies have worked out well for them, but not like the Bitcoin has worked out for them. And so in each case, my point of going down this path is that while, yes, there is the stereotype that people in crypto and people in Bitcoin are anti-government and or cypherpunks and or, just privacy maximalists, which they certainly are quite a few of those. This is not the lunatic fringe of the world. And these aren't just the young 30 some odd year old white bros that are out there looking to make a fortune and drive a Lamborghini and whatever. Those days are probably behind us, because I think that most of Bitcoin is never going to go 1,000x again. It's never going to go 100x again. I'm certain of that. Might it go 5x? Sure. But the people who...
This is not legal or financial advice.
Yeah, this is not legal or financial advice, because it could also go minus 5x. so there's that. But anyway, my point is that there's a surprising diversity of people in this space who have significant wealth, and even people who made wealth by conventional means are now accumulating Bitcoin. They're accumulating digital assets as a diversification play. You simply cannot leave those assets out when it comes time to do structured planning. They cannot be ignored.
So I want to talk about application and planning. There's 3 models of trust structures that I want to talk through to get ultimately to hear about outcomes. I'd like to hear from both of you kind of the outcomes that families or individuals with digital assets are seeking when they come to you, and what structures you've used in the past, and how. And I'm just going to tee it all up, and you can take it how you want, because there's the model 1, that is the trust to custodian, which is the simplest. And there's the model 2, which is trust to LLC to custodian, which adds the governance layer. And then model 3, which is a trust plus multisig distributed keys. And all of those models, the trustee directs, the custodian secures. And so with that being said, I want to talk a little bit about outcomes.
Sure. So full disclosure about me, I'm not an estate planning attorney. Invariably, when people come to me with these questions, it's predominantly focused on creditor protection. It's not necessarily about making sure that their children, indirectly it is, but it's not about, I want to get it in the hands of my children. And if it is, I pass it off to somebody like Matt, who's smarter than me in this realm. But traditionally, it's I have all of this, and I'm worried about getting sued. I'm worried about taxes, what have you. And so moving it from the individual to the LLC, or creating that intermediary step of having a trust own the LLC, is something that I work with my partners and my colleagues in the estate planning group, along with folks like Bespoke Group, in figuring out, okay, how do we do that? What's the best structure to achieve those goals? And for me as a corporate and finance attorney, it's that LLC structure. You've seen people, the Wyoming LLC is very popular simply because Wyoming is friendly to crypto. For my money, that does by itself doesn't make it better than a Delaware LLC or something like that. But the other sort of branch of this is that the people who often have the digital assets are also very concerned with anonymity. I don't want to form an LLC and have my name on there, Kyle Lawrence Crypto LLC. If I form it in Florida, guess what? I have to divulge my identity, and it's publicly available for anybody. Texas too, of like the 2 states I could have named, those are the 2 that are not great with anonymity. Wyoming is really good. Delaware is great. New York, of all things, is really good. So it's really important for the people who are trying to figure out, okay, how do I protect myself from creditors? I want to form an LLC. Okay, where do I do that? So there's a whole analysis that goes into what is it you're trying to achieve? Is it financial? Is it legal? Is it generational wealth protection over the years? So there's a large calculus that goes into philanthropy. Absolutely. Yeah. Sorry, that wasn't the, I'm a lawyer. I
What the heck?
I don't get those calls as much. Yeah, unfortunately. It's a different department gets those phone calls.
Yeah, a lot of what Kyle's getting at does have a threat of continuity to the estate and transfer tax world, because whether you're looking for asset protection or whether you're looking for tax mitigation, whether it is through charitable trust structures to not only benefit philanthropy, but also to generate a tax deduction, which people who have high income, especially capital gains taxable income when they've got low basis Bitcoin, for example, or putting wealth into a dynasty trust, for example, where you're trying to mitigate either state and or federal gift and estate tax, you have to fundamentally change your relationship with the underlying asset, whether this is Bitcoin or whether this is property, real estate, whatever. You have to change your relationship with the asset. So in the case of a limited liability company, if I want to create a limited liability company for purposes of protecting some of my assets, if I remain unilaterally in control of everything inside that LLC, and I use that LLC for clearly, objectively personal use, I'm not going to benefit from the corporate veil that the LLC is designed to protect. The LLC can protect my other business partners, for example. If Kyle and I are in business with each other and we create an entity, we capitalize that entity with Bitcoin or whatever, and we're going to buy some real estate and whatever with that, and then I get sued, the LLC protects my business partner, Kyle, from a claim that might attach to me. But if we are simply consuming these assets inside of here, let's say Kyle and I are best buddies and we buy a vacation home in Vermont and we decide, we're not really going to rent this thing out. We're just going to enjoy this as much as we want to. And we're probably not going to get a ton of asset protection out of that structure if that's where the structure ends, because we haven't fundamentally changed our relationship with the property inside this entity. In the case of trusts, the same thing is true. And so to kind of break down your custodial frameworks, Claire, if I have Bitcoin, for example, and I want to put that Bitcoin into an asset protection trust for my own benefit, maybe I live in a jurisdiction that permits me to create a self-settled asset protection trust for my benefit and for the benefit of the other people I care about. I can do that in Delaware. I can do that in Nevada. I can do that in South Dakota. I can do that in the Cook Islands. I can do that any number of different places. I have to then we're talking about crypto here, so I'm going to put that crypto in some type of signature control framework in order to substantiate the fiduciary control over this Bitcoin. Now, option number one is the trustee has qualified custody. Let's say we use a great custodian like BitGo or Tetra or one of these great qualified custodians that has banking authority and some federal charter. The trustee has to then onboard the trust with the qualified custodian, and I transfer my Bitcoin to that custodial vault. The trustee must be able to control the quorum that controls the signature to the Bitcoin. So again, back to my combination lock metaphor. The trustee should have probably at least a 2 of 3 multisig, which means it would take 2 out of 3 parties to have the shared combination to unlock the vault. That's what multi-signature does. So Tetra does that. BitGo does that. A lot of qualified custodians have that type of facility. But in that case, the trustee must control the quorum. There is a derivative of this, which is referred to as multi-party, multi-custodial multisig, effectively, which is maybe maybe the trustee has one signature, and that that trustee's signature controls a vault combination. BitGo, maybe another counterparty to that, and then maybe some third party has the third signature on that. So we have fragmented the combination across 3 parties. I have real concerns, I think, as to whether or not that holds up to establish legally recognized fiduciary title control. because in that construct, the trustee only has one of the signatures. It requires one of the two outside third parties to sign. And so the trustee cannot legally discharge their duties to manage the trust assets if they have to then rely on some third party outside of the trustee's control. And so, as the Bitcoin holder, I may be more comfortable with that model because no single party has my key material. But I, as the lawyer, am concerned that I have not substantiated title ownership in the trustee such that the trustee can fully discharge their duties under the governing state law and the terms of the trust instrument. And so the third model that we've done a lot of work on, we've helped pioneer this model, which is you establish a limited liability company, like Kyle is talking about. Use Delaware, use Wyoming, use Nevis for that matter. You can use any type of LLC, and we like to bifurcate the managerial roles within the limited liability company, which means the limited liability company, the operating agreement, kind of reads like a directed trust. You would have a general manager who we think should be an independent third party for tax reasons, which we can maybe get into, and also for asset protection reasons. And you'd have an investment manager, and that investment manager makes all the decisions regarding the underlying assets inside the limited liability company. Then you would onboard that limited liability company with a qualified custodian, Tetra, BitGo, somebody like that. And then the client would transfer the Bitcoin to that custodial vault titled in the name of the LLC. The client, depending on the custodial relationship, the client can actually have some signature authority over the digital assets. Again, you've got to be very careful to navigate this from an asset protection and tax perspective. But then you simply transfer the limited liability company up to any number of trusts that you want, depending on what you're looking for. You can put in your dynasty trust, your slant, your slat, your grat, your charitable trust, anything that you want to do like that. And so this allows the client to have a lot higher level of visibility and in some cases limited control to the underlying assets inside the limited liability company. They have an independent third party general manager who they have the power to hire and fire. The client, as investment manager, has unilateral authority to decide when assets get sold, when assets get acquired, the terms under which these things take place, what custodians we use. And then when the client transfers the limited liability company interests up to one or more trusts, those trusts should also follow the directed trust framework. So if we're using a Delaware trust, for example, the client would serve as the investment trust advisor and then be able to dictate the investment mandate or the investment policy statement of the trust, which includes the limited liability company, where the client also sits as investment manager. And so the client has absolute through-line visibility to all the assets inside the LLC, including the Bitcoin or the place in Vermont or whatever else the client has.
That was a phenomenal summary of really complicated structures, at least for me. And I'm an attorney, and that was a really great summary. And I just want to key in on something that you said that's really important. And I think that anybody watching this, it's really important to just remember, if you take nothing else from this, is that just creating the LLC and having a little paper assignment says I assign my crypto into the LLC, that does nothing for you. Matt, you nailed it when you were summarizing that. And that's a mistake I see a lot of people make. They think it's a shortcut, and it just doesn't give you the protection that you need. And when you're talking about the dollar values that are in all likelihood in play here, you want to do it right. You want to take the time, engage somebody, whether it's Bespoke Group or FRB or anybody else out there in the wilderness. Make sure you do it right. Spend the money, do it correctly, protect your assets.
Well, and the beautiful thing about layering these strategies like this, the estate planning attorney their ears will be perked up right now because they're thinking about family limited partnerships and limited liability companies where you can generate valuation. We like to say adjustments. Those adjustments are usually downward. So they often work like valuation discounts. And so depending on how the trust or the limited liability company is structured, it is very possible to create voting and non-voting interests in the limited liability company. and then the client retains a minority of the voting interest. Let's say we create a 98% non-voting, 2% voting interest inside the limited liability company. The client retains the 2% voting, so they have the ability to hire and fire the managers, make all the investment decisions, all that kind of good stuff. And then the 98% of the company is simply economic interests only. Then perhaps in year one, they are going to gift away 49% of the non-voting interest. Well, they're most likely going to get a minority valuation discount. They're going to get a lack of marketability discount, lack of control discount. And so very often, instead of the LLC interests being pro rata 100% of the value of the underlying assets, maybe they're worth 30% less, thereabouts. And so then you can do the same type of valuation adjustment planning, gift to a dynasty trust followed by a sale transaction with a promissory note. Grats of these discounts. There's so many things that you can do. I think the TLDR on this, since really our main audience here is for the attorney who is advising clients in this space, understand that when you're working with ultra affluent people, working with ultra affluent Bitcoiners and ultra affluent crypto people mechanically, structurally is no different than any other strategy planning that you've ever done. You have to understand the nuances of managing this digital asset that is a bearer asset. And as Claire was kind of alluding to, Kyle talked about this too. I mean, there's some idiosyncrasies about personality types sometimes, but these are really intelligent people by and large. And they are scientifically minded, so you may have to explain things a little bit longer to them than the garden variety entrepreneur out there. But the same type of planning that you've always done, you can still do for these people.
So now that the attorney listening, they've learned a lot today. And, next week when we're not sitting in the room with them, and a client walks through their door, that they can say yes to, I want to look at this from a different angle. We can wrap up on this. And Matt, I think this will be an opportunity to highlight the wealth operating system to Kyle. But, clients can be a risk, and the decisions that they make in life can influence the work of the attorney. And so I'm kind of curious to hear how some of this can break down. I mean, maybe what are some things to watch out for, and not to be like a gloom and doom, right? But what can go wrong with the structuring?
Well, Kyle alluded to it already. I mean, failure to transfer title is a huge part of it. I think, I was an estate planning attorney practicing for about 25 years. And the plans that I saw go wrong were usually the plans that were not funded properly, or when funding did take place, a few years down the line, the assets and the strategies were no longer aligned. Reporting becomes increasingly complicated. CPAs have to understand how to track basis on these assets. Clients who have tens of millions or hundreds of millions of dollars of wealth in the space, they usually have a lot of moving parts in their lives. The digital assets are usually only part of a much broader portfolio of wealth. They might have operating businesses. They probably have real estate positions. They probably have public companies. They probably have private investments. They probably have philanthropy going on in some shape or form. And so very often those things just are not operating in sync, because they have, over the course of their over the course of their journey in building their wealth, they have assembled discrete service providers who are each excellent at what they do, but there's nobody who's really riding herd over the whole thing. They might have somebody who's really savvy when it comes to the real estate portfolios, and they may have a really good CPA who understands that part, but maybe their CPA doesn't really understand their private investments, or maybe they've got an operating business and that's really not optimized for growth and for success. And so where we see these things go wrong is that as wealth builds, left to its own kind of entropy, I suppose, wealth has a tendency to kind of fall into chaos. Things are no longer aligned that once were aligned, and so where we come in, we're no longer a law practice. We don't have an active law practice anymore. So a client can't hire us to do their estate planning. Where we come in is we come in and we design and manage the systems that support wealth in all of its forms. And so we work with people like Kyle and the team at FRB on helping ultra affluent clients structure their affairs in a way that, as their wealth continues to grow and evolve, as their needs change, as their family circumstances change, somebody is keeping the dialogue going. FRB needs to change some of the business structuring. Maybe somebody, or we've got a good friend at FRB named Jeff Verdon. Maybe Jeff needs to help them with some more estate planning and asset protection structuring because things have changed. Maybe the clients have outgrown their CPA and they don't realize it. Maybe the clients need an outsourced CIO sitting inside of their company to help manage things for them. Maybe it's time for them to think about the next generation of decision makers in their family and getting them ready to lead the company or lead the wealth or lead the philanthropy or whatever it is. And so this is the work that we do for our clients in this space. And when clients have significant amounts of Bitcoin or Ether or Solana or whatever, or anything, and they want to reimagine how they think about their investments and then express their worldview through their investments, then we help them do that too. They want to bank in Switzerland. They want to bank in Singapore. They want to make sure that their investments are aligned with their philosophy. That's the work that we do.
Yeah, those are great points, Matt. What I find, if there's going to be a landmine somewhere in the chain, is I'm going to besmirch my fellow legal practitioners for a second and contradict something that we said in the very beginning of this conversation, which is, hey, estate planners, now you can add crypto and digital assets to the things that you're planning for. The thing that we see is that people assume it's like, oh, well, a digital asset is an asset like any other. I can plan for it just like I could ordinarily. And they don't understand that there's a fundamental difference in how you plan for that. It's a similar situation to where as an M&A attorney, I'm dealing with a counterparty and they say, oh, my lawyer who handled my divorce can handle the sale of my company. He's a lawyer. What's the difference? And I do see that problem a lot in any emerging nascent industry and technology. You're always going to have that. So that's something that I always see. And it's okay if you're a lawyer to say, you know what, I don't necessarily know the answer to your question. Let me get back to you. That is a perfectly acceptable thing to say to clients for all of you out there.
And lawyers can collaborate with each other. I mean,
what are the odds?
What are the odds? I mean, we can actually collaborate with each other and help clients get the outcomes that they need.
Thank you so much for today's conversation. If you are an attorney who wants to learn more, please drop in the comment box on the episode page on our website. We read through everything and we really only scratch the surface today. So tell us what you want to hear more of and we'll jump back on and have another conversation. Kyle, thank you for joining us on the Bespoke Audio Collection.
Anytime. Always good to see my friends, and thank you for putting together a great show.
Awesome. Alrighty.
Thanks, everybody.
Soon. Bye.
See ya.